Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, as always, Canada's leading employee-side employment law firm. I am going to be answering all your questions about all things employment law for the next 30 minutes or so. Before we get started, a couple things. One, send all your questions in as soon as possible. I like to get through all the questions we have before the end of the broadcast, but I sometimes am not able to do that if the questions come in towards the end of the broadcast. So if you send them in early, I'll try to get through them all before we go. Second, if you need to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, and you'll see that on the screen as well. Okay, let's get started. Got a couple questions so far. Question from Pine. When I received my offer letter by email, it stated my hourly wage would be $24, but I later noticed my pay stub showed I was being paid $17.20. That's a substantial difference. I just discovered that the emailed offer had a discrepancy. It listed $24, but the version I accepted on Workday, I don't know what that is, but I assume that's internal employment CRM software, showed $17.20. I'm wondering if I have any entitlement to the higher rate and who I should speak to about this. Yeah, so there are different things you can do here. So you were provided a job offer that said one thing, and you accepted based on that representation. But when you accepted the offer, this is where I don't know what Workday is, so it's a little confusing for me. But when you accepted it, it was at a lower amount. So you accepted the lower amount, but you weren't aware of it. So there's a difference between, legal remedy, do you have one, and, a viable solution at your employer. So with respect to your employer, I probably the right approach, if you want to keep working there at $24 an hour, is have a conversation with them about it. But I'll just say this. If I applied for a job because they said the wage was here, and then they pulled a fast one on me, and when I went to sign the contract, it was actually here, and they didn't bring it to my attention, I don't think there's any chance I would work there for very long, if at all, because they lied deliberately. So maybe it's a misunderstanding, maybe it's a payroll problem, who knows? So if I were in your shoes, I would talk to your employer first and say, hey, what gives? You offered me $24, that's what I accepted, and yet you're paying me $17.20. See what they say. I bet you they're going to say a bunch of stuff that doesn't get you back to $24 an hour, but who knows? That's your first solution. And that's probably the first stop that I would make, is talk to the employer and see if this is just a misunderstanding or what. Second, if you're provincially regulated, you have potentially certain remedies available to you under the employment standards legislation in your jurisdiction. Different employment standards legislations have different remedies, but there is one in BC, for example, that will allow you to collect lost wages from the date of, effectively the complaint to the date of a hearing, which is often in 12, 13 months, just for something like this, where there was a misrepresentation where you were lured in at this wage, and in fact, they were actually paid a much lower wage, and so that misrepresentation might entitle you to a substantial amount of lost wages, less mitigation. So if you get another job, then that money would come off. But nonetheless, it creates a substantial amount of risk for your employer, such that they might be on the hook to have to pay you a year's worth of pay at $24 an hour. So and I don't know. That's a unique BC remedy. I don't know if that exists in any other jurisdiction, but my point is there may be remedies available for you in the employment standards legislation of your jurisdiction. And it may be worth talking to a lawyer about. It may not. In BC, it would be. If you come talk to me about this, I'd be happy to represent you. But I don't know if it exists in other provinces. Um, if you want to keep working there, but just at the rate that you were hired for, I'd start by having a conversation with them. And if they don't bring you back to $24 an hour, or if there isn't a clear, reasonable explanation for why this occurred, if the job only pays you 17.20, then you may just want to vote with your feet and go work somewhere else. But you may have employment standards remedies, legal remedies available to you, and those may be worth exploring. I don't know if you're in BC or not, and I don't know if the moderator has my contact. But if you're in BC, please feel free to reach out to me for that remedy that I just discussed. There's my contact on the top left corner. But if you're not, I don't know about other jurisdictions. But first stop is probably talking to your employer and see what they say. Okay, I'm not going to identify this person, so I'm going to say this is a question from MM. I will be taking parental leave for 6 months. I have a base salary, but also a commission component to my job. If I have work quoted during my employment before I go on leave, but get signed awarded while I'm on leave, is the commission for this entitled to me, not entitled to me, or gray area? What dictates this? Yeah, so it's a great question. So I would imagine most people who earn commission, if not 99% of them, their commission formula entitlement is going to be enshrined in writing within either an employment contract or a commission agreement, some sort of sales commission agreement. And so I would look there first. And the reason why these are almost always in writing is because they're often based on formulas or percentages, and how much the employer is going to pay you, which varies from month to month or quarter to quarter, or year to year. That can often be a source of friction between employer and employee, and source of debate. And so having some concrete numbers where everyone can refer back to seems to be just sort of a prerequisite for commission employees. So I would look at that if you have one. If you don't, if you have an entitlement to the wages, I take a look at the Employment Standards Act. I don't know that the question if you're provincially regulated. I don't know the answer to that question off the top of my head. While you're on leave, you're not entitled to pay, but if you earn the pay before you went on leave, do you have an entitlement to that to that commission under the Act, under the Employment Standards Act in your jurisdiction? I don't know the answer to that question, but I imagine the answer is within the employment standards legislation or attendant regulations, and I would take a look there. But I expect for you, as with most people with commissions, probably your commission agreement or employment contract will spell it out for you, and you'll know from there. Also, if you're going on parental leave, your employers, talk to them. They can do lots of fun things with commissions, move them around, that sort of thing. They might be able to pay this to you anyway. And I don't know what kind of relationship you have with your employer. I don't know if it's a good employer or not, but employers, if you're going on parental leave, they tend to have some sympathy to that, and want to be good stewards of the economy and society, and have good reputations, particularly with social media. And so, I wouldn't be surprised if by the letter of the contract you weren't entitled to this money. They might be able to figure something out for you. So I take a look at your contract, your commission agreement, talk to your employer, and then also look at the Employment Standards Act. Bridget asks, my husband was laid off from his company. Okay, so what she means is terminated, actually. His employment was terminated from his company. He was there for 15 years. They offered 6 months continuance. Is that a good offer? Okay, so it is impossible for me to answer this question based on 2 sentences, 3 sentences, because I need to be able to review your employment contract and other materials surrounding your husband's employment. I'll just say, generally speaking, there are 2 types of severance. Most people are provincially regulated, so I'll just stick with that. Small severance, which is statutory, comes from the employment standards legislation in your jurisdiction, and big severance. Small severance, roughly 1 week per year of service to a maximum of 8 weeks, varies from jurisdiction to jurisdiction, but that's generally the ambit. Big severance, also known as common law severance or reasonable notice, is roughly 1 month per year of service to a maximum of 24 months. So a lot more money, and that's where you want to be. And what determines which one you get, small severance, big severance, is your employment contract. If you have a valid employment contract that you freely agree to that legally limits you to the small severance, that's all you get. Okay, so when you're asking me whether or not this is a good offer, if there's a contract that limits your husband to the small severance, so really he's only entitled to 8 weeks, then yes, it's a good offer. Okay, but if there isn't, he never signed a contract, or he has signed a contract but it doesn't contain an enforceable termination clause, and whether or not the termination clause is enforceable varies wildly by jurisdiction. Ontario famously, contracts that are older like that one, probably not going to be enforceable, or there's good odds that it isn't. I'm not saying that it isn't, but the odds are better than it would be in some other jurisdictions. But if he didn't sign one of those contracts, or there wasn't an enforceable termination clause in the contract, then it's a terrible offer, because he's going to have upwards of 15 months of severance coming to him, and so you need to talk to an employment lawyer right away. Okay, right away, like right after this call, you should or this broadcast, go talk to an employment lawyer. You can reach us if you want, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Just the last point about this, salary continuance. I mean, the industry standard is lump sum, where you get paid the entire amount at once. The employer can pay you a little bit less and you don't mind because you get it all at once. Salary continuance is usually entirely for the employer's benefit. It's there to preserve its cash flow across time, and also there will probably be some sort of mitigation clawback in the offer, such that if you find a new job, then in that time, then the employer owes you, say, half the remainder as a lump sum, or just doesn't owe you anything. Depends on what the language is in the clawback. But if your husband never signed an employment contract at all, 6 months on a continuance is a terrible offer. It's entirely for the benefit of the employer. So just depends on what his contractual situation is, and I'd talk to an employment lawyer, because it's that important that you do. Okay. I can't identify this person's name either. I'll just call them Jay. So Jay, I work as a nail tech at a salon part-time. Recently, my employer informed me that they want to change my status from an employee to an independent contractor in order to save costs, and they mentioned it would also benefit me. Well, I mean, your tax burden would be slightly different. However, I don't make enough money for this to be beneficial to me, and I prefer the job security and benefits of being an employee. Am I allowed to refuse to sign the contract? Can they fire me or retaliate if I say no? Okay, so if you say no, probably they're going to do one of three things. They're either going to keep you on in your current role as an employee, they're going to fire you, or they're going to unilaterally impose the change upon you. If this is a giant payroll structure, employment structure change for all of the employees, and listen, if you were employees and the only difference now is they're not paying payroll taxes, so that's why they're doing this, you're probably still employees and not contractors. If you have no control over the tasks you're doing or your schedule, you're going to be employees. It sounds like you're still employees, not contractors. So it's I mean, it matters to you from day to day, but if you lose your job, it's not really material, but probably, I mean, I'd have to look at the facts of your situation. But I think I would talk to them about it, if you have that kind of relationship with them. But yeah, I mean, there's a real risk they could fire you. Then you would have an action for severance against the employer. The challenge for you is, so we've talked a little bit about severance in this broadcast, and severance is just money if you're fired today, money for not having to, uh, money paid at your regular wage rate across a certain amount of time without having to work to obtain that money. And if you're entitled, like if you didn't sign an employment contract that limits you to small severance, and you're entitled to big severance, the amount of severance that you're entitled to is informed by 4 factors: your age, length of service, position, availability of similar employment. And I'm guessing that part-time nail technician, you could get another job somewhere else as a part-time nail technician like that, paying you roughly the same, which means that in any severance claim, there's probably it's probably going to be extremely low value, unless you've been there for 20 years or so. But it's also, if you're part-time, then the amount of severance you're entitled to is a function of, or calculated at, your whatever your earnings are in a given month of time. So I don't think there are a ton of good options here. I would talk to them first. You seem to want to stay there. You seem to like the job. I talk to them first, see if you can arrange anything. If they're just going to do this anyway, you may want to vote with your feet. Go, you can get another job somewhere else pretty easily, I imagine. If there are specific reasons why you want to stay there, you have the conversation with them, and if they don't bend, they don't bend, and they'll probably just impose this on you. And can, at that point, you trigger your termination and claim constructive dismissal and seek severance? Well, the severance you get would probably be very minimal, and you'd probably need a lawyer for that, and it wouldn't be cost effective for you. But also, I don't know if that's enough of a change to trigger constructive dismissal. It might be, maybe not in your particular situation. Maybe with a 20-year employee in a different industry. It could be, depending on what you're losing out on. But the challenge is you're effectively going to make the same amount of money. So it may not be enough to be a constructive dismissal. So not a lot of good options there. I would probably start with talking to the employer and see if there's any flexibility there, and if there isn't, you'll have some decisions to make. Michelle asks, is it normal for your employer to remove your access to the company if you are on short-term disability? I don't know what normal is, I guess, but it varies from company to company. But I would say more companies are doing that for security reasons. Yes, we live in a world where and control. We live in a world where there are security breaches all the time, where they can cost companies millions and millions and millions of dollars. So yes, best practices, I think, are moving from a technology perspective and an access control perspective, are moving in that direction. I don't want to say this person's name because I don't want to reveal who they are. So I'll just say NT asks, my manager made discriminatory remarks. He told me to walk out the door and reduced my hours after I called in sick. I feel targeted. Could this be a constructive dismissal? Yeah, certainly it could be, but telling you to walk out the door is not discriminatory. Telling you to walk out the door because of, some gender or sexual orientation or racial epithet would be, right? Reducing your hours. So he reduced your hours, sorry. If your hours were reduced by 20% or more, that's usually a constructive dismissal. If it's less, it has to be paired with something else. If it's paired with some problematic bullying and harassment behavior, it can be a constructive dismissal. But you need to look at what's your employment contract. Like, if your employment contract limits you to a small severance, you don't really want to trigger a constructive dismissal. What I would instead do is I would use my time there where I'm making money as controlled working notice, where I would look for another job while getting money from this job. And then when I found another better job, I would move on to that job. That's always open to you. That might be the best play here. However, If you don't have an employment contract or one that limits your severance entitlements, and you got 10 months of severance coming to you or something, yeah, you might want to trigger your constructive dismissal. And also, your window to do so is very, very short. It's the Supreme Court of Canada accepted 2 months. In the famous Potter case, there's a case in BC that accepted 3 months. I'll back up here a second. So if your employer unilaterally changes a fundamental term of your employment, in this case, reducing your hours and therefore reducing your pay, and the amount of hours reduction is fundamental to your employment, it can be a constructive dismissal. But if you don't object to the unilateral imposition, then eventually, and you just keep working, eventually you're deemed to have accepted the imposition of reduced, in this case, hours, or the change in a fundamental term, and therefore you can't 6 months down the road go, oh, actually, I object to this constructive dismissal. Well, no, you made your election to accept the changes by working under them, and it's constructive dismissals put a lot of pressure on employees because they have to terminate, in effect, their own employment, and then they don't have any money coming in. It's very, very challenging, and it's not something that any employee should do on their own. If you ever consider triggering your own constructive dismissal, don't take any action until you talk to an employment lawyer, generally speaking. Okay, but your time windows are very, very short. So yes, you should talk to an employment lawyer. You can reach us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But NT, you could have something here, or it might be nothing, and you should just treat this as a working notice period for you. I don't think your employment's going to continue there very long either way. It doesn't sound like you want to work there or should work there for very much longer. But talk to an employment lawyer, find out if you have value in your case, and whether or not, and do it fast, because you have to determine whether or not you're going to trigger your own constructive dismissal to pursue monetary compensation, and you only have about a 2-month window from the date of the reduction of your hours, provided that reduction is permanent, to do so. Okay. I'm going to just call this person B. I transitioned to a new position at my company with the understanding that I would need training for the role. My boss was then let go, and I never got any training. It's been 8 months. What can I do? Well, do you need training to figure out the job? I mean, training is, listen, if you're going to be a pilot, X-ray technician, training is very, very important. But a lot of times learning on the job, shadowing, doing can get you to where you need to go, right? And so does it matter? I'd be much more concerned if you are sort of in this promoted siloed role where your champion in that promotion has been fired, that you're just sort of dangling in a position that isn't going to work out. Like eventually they're just going to terminate you. I've seen several times in my business career before I was a lawyer, but I see it often as an employment lawyer as well, where someone will be very successful in some position, like a sales manager, be promoted to, which has a defined role, structure, objectives, have your people bring in sales, and everyone gets a slice of commission and all that stuff, to business development manager, which is just sort of this more nebulous concept of, bringing new business to the company. It was impossible, or generally impossible, to really quantify how that's going. And then, 6 months, a year later, the company just fires that person because they're in a position that is sort of this siloed thing outside of the structure of the organization. So if that's what's going on with you, yeah, you should probably do something about it and see if you can get back into a more central role. There, you have a second question here, B. I keep getting handed tasks without proper training, and I'm not learning the position at all. I left a good position for this under the guise of career development and growth. Yeah, that's what I was just talking about. That can always be a challenge. I just don't understand why you're not learning from doing the job. And so if the training is necessary, have you asked about it? Can you follow up internally, sideways, with people laterally who can assist you with learning what you need to learn? I would, but yes, I would be very concerned as to where you are. But this isn't an employment law question, unfortunately. This is how do you navigate the economic realities within your business and the political realities of the situation now that you've been promoted into this position and the person who promoted you has been fired and you're not getting the support you need. That's a political question, and unfortunately I can't really answer it, or it's a non-employment law question. I wish you great luck with that, and maybe your answer is to talk internally, maybe it's to seek people laterally. I don't know, but there certainly are options I would try, but that's outside of the scope of legal advice. So I'm going to leave it at that, but I do wish you be great success with that tough situation. Fifi asks, I'm currently on short-term disability leave and also pregnant with my paternity leave expected to start in November. I asked Human Resources if I could use vacation or sick days to cover the gap between my last paid day and the start of my short-term disability. But instead of answering, they just told me to provide a personal email because my work email would be shut off by the end of day. It felt off to me, especially since a coworker on similar leave kept her email access, and some of my benefit coordination is tied to that account. It's not really a question there. So, Fifi, does it feel off? Yeah, it might. Employers, when you're gone for a period of time, you're a liability to employers now. They've got to have you come back. They can't really replace you, because if they replace you, then what happens when you try to come back? You're going to have a claim against them for not getting your job back when you came back, for discrimination on the basis of disability or because you were on a maternity leave. So yeah, it might feel odd. I've seen over the years employers certainly not take too kindly to absences or stacked absences of the kind that you're talking about. Can they do anything about it in law? Well, they can, but not without penalty. In terms of access, there's nothing wrong with taking away your access per the earlier question that I answered in this broadcast. The employers, for security reasons, quite often turn off access when you're going to be away for a period of time. In terms of your question about covering the gap, you may want to ask it again. You may not want to. If it feels odd, you may just want to leave it alone and circle back around to fight another day. It's again, this is not something I can answer. It's not really a legal question. It's a internal politics question. If it felt off to you, it might have been off, but what can you do about it? Not much. You're not going to change your sick leave. You're not going to change your maternity leave. And you're really sort of at the mercy of the employer at this point. If the employer does something, you're going to have a legal remedy. Whether or not you should pursue it or not depends on the amount of the legal remedy. But if the employer terminates you, for example, while you're away, you should talk to an employment lawyer right away. I know. So we've got two more questions. I'm just going to race through these, even though we're out of time. Margot asks, if I'm concerned I'm getting slowly pushed out of my job, what documents should I start collecting? I'd keep a log book of everything that happens. Who did what on what day, dates, times, what happened. Not like not an emotional logbook about how you feel about it, but just what happened and when. Any relevant emails, your employment contract, any other documents. You want to save those. Certainly you don't want the employer to know that you're moving those away, but certainly it's much easier to deal with employment law claims if you have copies of your relevant documents. But I would keep a logbook for sure, and certainly you're entitled to keep your employment contract if you have one on your home computer. So, but yeah, I keep a logbook, and I wish you well with that. I hope it goes well. And then F asks, this last question says, I was placed on temporary layoff around 6 weeks ago. I'm due to return to work soon, but my employer says I need to sign a new contract. It is also for less pay. Is this legal? I mean, short answer is no. If they don't call you back, then you have a termination. You have a termination claim against them. Whether or not it's worth it to pursue depends upon what your existing contract says and your, age, length of service and position. FS, I would talk to an employment lawyer right away. If they're trying to get you to sign a new contract, chances are the old one isn't good, so you might have some good money coming to you. But if it were me in your shoes and there was a difference between the two contracts that was material, that's why you need to talk to an employment lawyer. I would, and I'll put I can see the information on the screen, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But if it were me, I would probably just refuse to sign the contract and see what the employer does. But it depends on if there's material difference and there's good money. There's good money to you after getting terminated. If there wasn't, you just want to stay working there at your old pay, I might talk to the employer. You have different remedies. You have employment standards remedies. It's no. The short answer is no, they can't do that, and you'll have remedies available to you. But I would talk to an employment lawyer right away. Okay, good. We got through all of our questions. Thanks for getting them all in. That's me on the screen, as you can see, Dan Balkaran. I'll be back in 2 weeks, I think, at my regular time slot, 10:30 a.m. Pacific time on Fridays, and join us on Monday, August 18th, 1:30 p.m. Eastern Time with Chris Justice. He'll be answering all your questions about all things employment law. Other than that, thank you everyone for joining. Have a wonderful weekend, wonderful, safe weekend, and I'll see you next time.